I want to talk to you today about resolving a DUI case, how a good lawyer enters into negotiations and what steps they take to get the best possible result for a client. Obviously, the goal of resolving any case is to try and get the charge dropped. Or if we can't, we try and get the lightest sentence possible for impaired driving. And that's assuming the client doesn't want to go to trial, for example, okay? So let's think about this. So first of all, we will get a hold of the police reports. And when I get a hold of the police reports, I will sit down with the client and I'll go, oh, this is a great case. You have a good chance of winning, or you know what, it's pretty good. You have a pretty good chance of winning, 50-50. This is a tough case or a rotten case. We're not going to win. It kind of breaks down in a continuum from really good chance of winning down to zero chance of winning, unfortunately. So with that in mind, I can now go to the Crown. I say, well, what do you want to do? Well, I want to go to trial because you tell me there's a good chance of winning, or 50-50. I said, you know what? I may be able to negotiate a careless with this. So if I go to the Crown attorney, if I'm convinced the Crown cannot repair their case, and that's a big if, I've got to be convinced of that because sometimes they can, I will, in certain circumstances, if they absolutely cannot repair their case, show them the deficiency, and they might offer a careless driving or even withdraw the charge. So what a great result that would be. So that's for cases that are, winning cases. And if the Crown says no, well, off to trial we go. We obviously have a good chance of winning. So let's take a charge, though, on the other end of the scale where, God, it's a pretty strong case against you. I'm going to be candid with the client. Still, we have to negotiate the best result possible with the Crown. We need to present the client's good background, their good prior character, they got no record. We enter discussions, and the Crown might be in a jurisdiction where they got a delay problem, right? So that's great. We surprisingly of lately in Ontario are getting some careless even on stronger cases because that's a bit of delay problem going on propagated by COVID. Sometimes yes, sometimes no, but the bottom line is we have to negotiate the lightest possible deal. There's mandatory minimum sentences for DUI. That's oftentimes a good result if the Crown's got a good case with high readings. And they're doing that a lot now. They're offering pretty good deals due to kind of a lingering delay problem for trial delay due to COVID. So as a lawyer on a DUI case, here's the bottom line. I'm looking at the cost-benefit analysis of proceeding to trial, what are my odds of winning, versus the deal I'm offered, and then meeting with the client to figure out what is the best option for them. Now, if the deal offers to drop the charge, that's like winning at trial, and you do it, obviously. You always pretty much take a careless driving when that's offered. That's a fantastic result, too. And oftentimes on a stronger case, especially with high readings, if you could negotiate the mandatory minimum penalty and get the client back driving, a little bit irony in that saying that, back driving with an ignition or lock, that's a great result. And clients will often tell me that you know what, I just want to get back driving, get me the minimum result, and away we go. So that's the approach we take to resolving DUIs and meeting with the Crown, and it's a rewarding business, and we just love the particular business within, and thanks very much for watching our videos. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.